Thank you so much, sir, for the detailed presentation on the subject. And I hope that the students have got a very clear idea about what they are going to discuss, what they are going to study in the this entire semester regarding this subject. Thank you so very much, sir. Now, I request Dr. Suman to give an insight about the humanitarian and the refugees law. Over to Dr. Suman, please. Dr. Suman, yes. Over to you, ma'am. You are not audible, ma'am. Ma'am, you are not audible.
Am I audible now?
Yes, you are audible now.
Not audible now?
Yes, ma'am, you are audible now. Yes.
I'm audible now.
Yes.
So a very good afternoon. Okay. A very good afternoon to all of you. I hope all of you are in best of your health and doing well. And let me begin by expressing my thanks to the organizers for giving me an opportunity to orient my students onto the paper which is very relevant in contemporary times. I am dealing with one paper of international law, that is International Humanitarian and International Refugee Law. Now this paper in fact has assumed considerable importance in the recent time. This international humanitarian
Ma'am, you are not audible again.
International Refugee.
Your voice is breaking.
Refugee Law.
Ma'am, you can turn off your video now. Then it will.
Yes, ma'am. Ma'am, your voice is breaking, so you turn off your video. I think then it would be better. It's breaking. Your voice is breaking, ma'am.
That
I think there is some technical issue with Dr. Suman. So in the meantime, let's proceed with the next presenter, and that is Dr. Ambreen Ajit. So I request Dr. Ambreen Ajit to please enlighten us on intellectual property rights. Over to you, Dr. Ajit.
Very good afternoon to all of you. Ma'am, I'm audible?
Yes, sir. You are very much audible.
Okay. So today I'm going to give the presentation over the subject intellectual property rights. And I'm thankful to the organizer for giving me this opportunity. Intellectual property right, just I'm going to share my slide. Intellectual property right is generally it is seen as a part of the corporate law. Okay, and when we talks about this paper, it is a specific kind of paper which protect a kind of property, that is intellectual property. Actually, what is the subject matter of this property and why it is so relevant these days? I think my screen is visible now.
Yes, sir. It is visible.
Yeah. So this intellectual property right is a specific kind of property rights. Basically, it is related to creation of human intellect, that what is going to result, which is the result of the human intellect, and how it was immersed. First of all, just I want to discuss that how we perceive intellectual property in 21st century. It was not in late 18th century or 19th century. Prior to that, because you know that this copyright, patent, all these things are 400-500-year-old concept, not new concept. But at that time, they were came with a certain different objective. Take the example of copyright itself. In case of copyright was not given at the beginning to the authors. Earlier in 15th to the 19th century, it was given to the printers. Then after it came to the authors. In same way, patent was not for the inventor earlier. Patent was mainly granted to import the patent from any other country to develop your own economy. Later on, after this, mainly after the 1850 onwards, the concept of intellectual property started changing. And after the Paris Convention and Berne Convention in 1883 and 1886, okay, they got this importance at international level. But even that time, there was no terminology like intellectual property rights. It was that industrial property and aesthetic property. So generally how this concept came, that whoever is inventing something, whoever is creating, writing something, there was need to protect their idea, the idea which has been already expressed or applied in any form, in tangible form. Because unless and until your idea is not reflected into tangible form, it cannot be protected as intellectual property right. Whereas intellectual property right itself is a kind of intangible property. So it is a study of a kind of property law. Okay, whether it is a kind of property law, property may be tangible, intangible. You might have read this Transfer of Property Act, Sales of Goods Act, all these things, lease, mortgage. Okay, so in intangible category or incorporeal property, this intellectual property category comes, which include now these days several kinds of IPRs, including this trademark, copyright, patent, design, semiconductor layout design, all these things. But the basic requirement in this is that it is the result of human intellect. That means what you have created with your intelligence or intellect. Then this industrial property and aesthetic property. Earlier industrial property was like this patent and trademark mainly, which was recognized under the Paris Convention. That is patent, trademark and design. Aesthetic design was also, aesthetic property was also covering this copyright and design part. And overall now these come under the umbrella terminology that is called intellectual property rights. But after TRIPS, it has been changed. It has been changed. That means we have incorporated so many kinds of intellectual property rights in India also. And the main objective of this TRIPS was to give a minimum, a standard for all kinds of IPR, minimum standard for the protection of all kinds of IPR in this TRIPS agreement. So India was also a party of WTO agreement, and being a WTO agreement party, TRIPS was also binding on us. And being a developing country, we had 10 years transitional period. So earlier we had this copyright, patent and trademark prior to the TRIPS also. But during the TRIPS, we have enacted new kinds of, even design was prior to TRIPS also. But after TRIPS agreement, we have enacted Geographical Indication, Biodiversity Act, Plant Variety Protection and Farmer Rights Act, Semiconductor Layout Design Act. Okay, and we have amended a few provisions of Patent Act, and we have enacted a new Trademark Act. So after this TRIPS agreement, this became a mandatory part for every country who were the part of the WTO to give the minimum protection to the intellectual property rights. And then after, BCI also implemented it as a compulsory paper in 5 years LLB course, as well as a optional paper in 3 years LLB course. In certain places, it is also as a compulsory paper in 3 years course. And it is mainly a part of corporate law. Objective of this paper is, first of all, to provide the general aim and objective of intellectual property law. For what purpose it is, how it has been evolved, okay, what was the objective even at the time of its origin, and what is the objective in 21st century. What are the general principle of intellectual property law, or very general principle for different kinds of intellectual property rights. Then understand the basic principle of a specific IPL, just like copyright, trademark, patent law. Okay, and then about the enforcement procedure of this, because IPR will be once it will be granted, then the person who is holding the IPR will have a certain kinds of right, as well as to restrict the others, any third party, not to infringe his any kind of IP. So in that case, enforcement is also very important. Without enforcement, only IPR will not serve the purpose. And recognize relevancy of IPR related international convention. There are certain basic or very, very important conventions like Paris Bond Convention, WCT, WPPT and all. So basic features of these conventions. So, this course has been divided into 7 modules. So it is IPR 1. So generally in IPR 1, we cover trademark, then design, and this geographical indication. So these 3 major, and they are related also to some extent. So under this trademark, design, and geographical indication, we have divided into 7 modules. So module 1 is about the general introduction of IPR, because it is IPR 1 paper itself. So it is about the general overview of whole IPR. So introduction of IPR, general concept, general nature and basis of intellectual property rights. What are the kinds, just like industrial or aesthetic or copyright, trademark, patent, design, geographical indication, biodiversity. Okay. Then general enforcement rule and international legal instrument, certain general principles, just like this national treatment rule, principle of exhaustion, etc. In module 2, then we start with the proper trademark law. From trademark, generally we start about the protection, this concept of trademark. What is the trademark? What is service mark? What is good concept of goods under Indian trademark package? Well-known trademark. You might be aware with all these kinds of trademark, which is here Netflix, Amazon, Google. Some are just like service mark, just like Netflix, it is a service mark. Okay, Airtel, it is a mixed goods as well as service mark. Tata, goods and service mark. So different kinds of mark we will study in this, and what is the basic concept behind that. Function of trademark we will see as a general principle, and needs for the protection. Why we are protecting trademarks? Because it is even the oldest IP, oldest intellectual property rights. Trademark is the oldest intellectual property right. Then registered trademark, unregistered trademark. What is the benefit of a registered trademark? How unregistered trademark is protected? So all these things we will discuss in module 2. Then use of trademark on goods and services in advertisement, as well as domain name, the new concept after this development of online trading and all. This domain name also covered under the trademark these days. Registration of trademark, procedure, grounds of refusal, which kinds of trademark may be registered, which kind of trademark may not be registered, certain prior or vested rights of trademark user, rectification in register. Then there are very important part of the trademark is about the grounds of refusal, that is absolute ground of refusal and relative grounds of refusal. So, and that is the main, you can say it is a core part of trademark. Okay, so we are going to discuss it also, that absolute grounds of refusal of registration, what is the distinctive character, descriptive customary of bona fide practices of trade and others absolute grounds for the refusal under trademark 99, acquired distinctiveness, well-known trademark. Okay. Then module 3 is about the relative grounds for refusal of registration, later trademark similar with the earlier trademark, then earlier trademark and well-known trademark, provision of registration even for different goods and services, factor for determination registered or used in good faith. If someone is doing the good faith, using the good faith, any trademark, then what kind of the rights that person will have. Refusal of registration on the grounds of passing off, if it is an unregistered trademark, then how it can be protected, passing of remedy, okay, or under the law of copyright, what kind of the any trademark, that means if it is it can be registered in copyright or not, or if it can be registered, then what is the distinction between the mark itself, because any mark first of all is artistic work. So that artistic work, to what extent is protected under copyright and when it will be protected under trademark. Then prior vested rights, honest and concurrent user, because sometime it may happen that the similar kinds of mark may be used by the two traders, and one trader is honest and concurrent at the simultaneously they are using. Then what is the right of the honest and concurrent user? Acquiescence, principle of acquiescence. So this is about in module 3. Module 4 is about passing off and infringement. So in this, we will see that what is the difference between passing off and infringement. Mainly it is the difference between registered and unregistered trademark. Okay, so passing off for the similar kinds of good, different kinds of good, trans-border reputation. Okay, then exception to infringement action and trademark dilution. Module 5 is about the contemporary development in the trademark law, protection of trade dress. These days, there is a new concept which is a part of now these days of trademark, that is trade dress, because certain business houses or business category, they are using their own unique kind of the dress. That dress means what? Not dress means apparel. Dress here means that they are giving a color combination of certain kinds of color combination to particular their business. Just like take the example of Idea, yellow and sunflower, Airtel, white, this red and white, HDFC Bank, blue and red. So just like they are using certain color combination in certain ways, so they are giving their trade as a particular covering. So that is trade dress and how it can be protected, color combination can be protected or not. Then tarnishment of trademark, comparative advertisement, when you are comparing with the other kinds of the trademark or goods or services, and there may be direct comparing, then whether it will be allowed or not. Disparagement after comparative, when you are doing this comparative advertisement, sometime may cause disparagement to the other products also. So what is law relating to that? And in case next principle is exhaustion of IPR. That means once IPR, this exhaustion principle is recognized under the TRIPS agreement also, that once the goods will be released from the producers, that means it will go first time into the market, then the rights over that physical goods of the owner will exhaust. So that is the principle of exhaustion. So we will discuss in detail. Next is about geographical indication. So geographical indication is not about the result of human intellect here, but it is the rights of the community. Because few kinds of IPR, just like patent, copyright, trademark, okay, design, that is individual or this company will get the protection. But in case of certain kinds of IP, community is going to get protection. So one of them is this geographical indications. So under geographical indication, there are certain goods which are known with their geographical origin, just like Darjeeling tea, okay, Banarsi sari, Kanjivaram silk. Like these kind of the product, they are known by their geographical origin itself. So this kind of the protection has been granted under the TRIPS also, and because India was a party to the TRIPS, we were bound to create a new legislation. So we have created this Geographical Indication Act, okay, and now we are protecting geographical indication, and we have registered more than 2000 GI presently in India, and this GI specifically give this right to a traders group, because whoever is dealing with that particular goods, take the example of Banarsi sari. So those who are dealing with the Banarsi sari in Banaras region, they will have to become the member of the society, and that society on the behalf of the traders of the Banarsi sari of the Banaras, they will apply for the geographical registration, geographical indication registration, and once it will be granted, then they will get a tag number. So they can use this GI indication tag, and now this is the new logo which has been accepted by the government of India for the GI. Okay, so this logo may be used for indicating that, okay, this is the GI product and this is the registered one. So a special kind of protection has been given that no one can use the name, similar kinds of name, by saying that again they are selling the kinds of Banarsi sari or any other kinds of goods. So we will discuss, we will deal about this in this module 6, registration, grounds for refusal of registration of geographical indication, then protection, duration, renewal, infringement and penalties and remedies, and conflict of GI with the trademark, that what are the difference between the GI and trademark. Then module 7 is about the design. design is also very specific protection, because this is one of the kind of IPR which is protected in most of the IP. Such design may be protected under copyright law also, design may be protected under patent law also, design may be copyrighted also, design may be protected under design also. So first of all, we will see that how this design is protected under different kinds of other IP. Then we will see that what kinds of design may be protected under Design Act. Okay, because design get the patent also, functional design. So if you are creating a functional design, so that may be protected under design as well as in the patent also. If it is only aesthetic design, so you may go for the only copyright protection. But if it is aesthetic design which is getting the mechanical production, then we will come under the Design Act. So we will see, generally we see all these things under the module 7, rational basis and subject matter of the protection of industrial design, registration, cancellation, piracy, or infringement of design, then overlapping of design, copyright, and trademark. That what is the difference between these three, and even there are sometimes overlapping with the patent also, functional design, because if you read the US law, they have a separate law, design patent. Okay, but here generally we grant design patent under the patent law itself. And this industrial design is mainly for the design, which is not come under the patent law. Then what is the relevancy of the subject these days? Okay, so I told you that after TRIPS agreement, it has become very important that every nation of the world, those who are the member of WTO, they are bound to protect. And after 2015, because the even this least developed country had only 20 years transitory period. So after 1995 to 20 years, that is 2050. So 15. So after 2015, now all the member of WTO are bound to give the protection to IP. Okay. So India has also now under this frame. So it is the most one of the most important contemporary law which does the every aspect of human life. I used to say that since the morning to the night, you will whatever you are using, that is under the copyright protection, even from your toothbrush to your bed sheet. All these things is covered under this these days under the IPR. Okay, so one of the important part of corporate law, but at the same time, it is not only the part of the corporate law, because GI and this Biodiversity Act, okay, and this other kinds of traditional knowledge and all, these are also the part of the intellectual property rights, but they are the part under the community rights. Community will hold the right over that, not the individual or corporate. So these, you can say the core IPR, just like patent, copyright, and trademark, they are the part of the corporate law. But as geographical indication, traditional knowledge and all, they will go under the community IPR. And this is one of the good paid litigation subject, specifically. That means when you are doing the practice in industrial area, or just like Delhi and Noida and any other industrial, so certainly the main of the cases will come from the trademark and copyright, as well as if you are background from the science, then you have much scope in the patent law also. Because patent law these days, that is, you may apply for the patent agent and you may become the patent agent, as well as after doing LLB, you may become the patent attorney. Okay, so if you have a science background, then you have an additional advantage in this, but not only for the science, but for any general student. That is now, this is an emerging area, and it is an interesting area that if you want to develop in this. So this is, I will say that this is the this is increasing. There is one study, practical study has been done by one social site, that up to 2030, okay, that litigation in IPR just it will be 3 times in comparison to today. And this paper is also included under the certain competitive examinations. So this is about the intellectual property part 1. If you have any question, then you can ask.
Excuse me, sir.
Yes.
Hello.
Yes.
Sir, can we see this subject in the light of the private international law subject, which we have studied in semester 3, wherein the international organizations have a patent, and the various conflict between the international patent and the Indian patent? Will that also be covered in this, sir?
No, generally it is a part of public international law, not the part of private. Okay. For First thing, that means international whatever convention. Private in the sense that when it is a jurisdiction about that some in some country you have a patent infringement, and then you are you want to challenge that, or you want revocation or filing infringement procedure. So for that purpose also, that is the standard has been laid down. Most of the municipal law has been enacted accordingly. So you will have to file suit in that particular country.
Okay. So will studying this particular subject help in that particular purpose, sir?
Yes, certainly it will help. That it is not about, I will say it is not directly related to private international law, but just only about the jurisdiction, and jurisdiction is very clear because certain IP are very territorial in nature and certain IP are universal in nature. That even though it is not registered, but you may protect, you may protect your rights. Just like take the example of unregistered trademark. So if you have a trans-border reputation, then on the basis of common law principle of passing off, you can protect in that that particular area or that particular region where your trademark has been infringed. But take the example of patent, which is the registration is must. So unless and until you have not registered in any particular country, okay, you cannot file infringement proceeding. So for patent, it is very clear that you will have to file patent first of all, then you can start infringement proceeding. And if you are not filed within the time period, then after also you cannot file further, you cannot take a registration, and that country person will be free to infringe your patent. Okay. So all these things, it depends upon that how you have started protecting your IPR at the beginning. And for every kind of IPR, there are separate laws. That is not uniform. If you want to protect patent, you will have to read patent properly. If you want to protect copyright, there are different kinds of convention and principles. If you want to protect trademark, there are different kinds of principles. Okay. So it is not that, yeah.
So you mentioned the name of few of the companies which are having their trademarks, and like Tata and other companies. And if any international company's trademark is being used in a wrong way or without any permissions by any Indian company, then obviously that company would like to file a suit within India against that particular company, Indian company. So this particular subject will help in the future if we want to establish ourselves as a lawyer from any side for that particular kind of cases. Am I right, sir?
Certainly.
Right. Thanks a lot, sir. Thank you.
Hello, sir. Good evening. Am I audible, sir? May I ask?
Yes, Priya, you are audible.
Yes, sir. So I wanted to know, I saw that there is one paper of IPR in the 5th semester as well. I wanted to know if that is also is an optional or a compulsory paper, and if yes, then how are these two papers different? And if we end up taking, yes, sir.
Yes.
And if we end up taking IPR in this semester, is that like a continuation of the same thing? I was really confused as to why are these two papers separately put in our curriculum. Thank you, sir.
Good question. I told you that IPR covers 7 types of IPRs. Okay, patent, copyright, design, trademark, plant variety, geographical indications. So that has been divided into 2 parts. So first part, that means this paper, 4th semester paper, will cover trademark, geographical indication, and design law. Paper 2 will cover patent, copyright, and plant variety protection and trade secret laws. Okay, so that is completely different. And it is your option that whether you want to choose IPR 1 or IPR 2 or both. Okay, so it is the complete discretion of some student has chosen only IPR 1 or some they used to come in IPR 2. So in this semester you will read only trademark, this GI and design.
Okay, sir. So IPR 2 is also not a compulsory paper; it is an optional paper only, right? In 5th semester. Okay, sir. Thank you.
Any other question?
Okay, thank you so much, sir. I think no questions are there. If anyone is having any other question, then you can directly contact us, sir, after this program. So thank you for giving your valuable information regarding the concept of intellectual property rights from the very beginning and discussing the entire syllabus in detail. So I hope it's really going to help the students. So thank you so much, sir. And
thank you.
There was some connectivity issue with Dr. Suman. So I don't know whether she's back or not. Dr. Suman? No, I don't think that. I think still there is some connectivity issue with Dr. Suman, but no issues, as as we have informed you earlier also, that this entire program will be uploaded on the website and also on the YouTube. So if this subject, Dr. Suman, you are here? So can we start with your presentation? No, ma'am, you are not audible. Ma'am, you are not audible. No, ma'am.
Unmute yourself, ma'am. Unmute yourself.
Unmute yourself. Ma'am, unmute yourself.
Now, I'm audible now?
Now you are audible.
Okay. Can I start now?
Yes, please, ma'am.
Okay. So, a very good afternoon to all of you, and I hope all of you are doing well and are in best of your health. And let me begin by expressing my thanks to the organizers for giving me an opportunity to orient my students onto a paper which is very relevant in contemporary times. Now, I'll be dealing with the one paper of international law, which is International Humanitarian Law and Refugee Law. Now, these two papers are part of international law. And since all of you have studied international law, which was a compulsory paper, so this, if you opt for this paper, that certainly would benefit you in the sense that as far as the understanding of this paper is concerned, for that you need to have, first of all, the students in fact must have gone through this public international law. Since that paper has already been studied by you, so therefore you won't be facing any difficulty as far as this paper, International Humanitarian and Refugee Law, is concerned. Now, the question is as to why humanitarian law and refugee law is being taught together, and that too in one semester. So what is the relationship between this humanitarian law and refugee law? So there is a close connection between humanitarian law and refugee law, because if you make an analysis of this humanitarian law and refugee law, what do we get? That the major provisions relating to human rights and protecting the dignity of the person are being covered by these two international conventions. So here lies the importance of this paper, and in fact there is not even a single day which in fact does not cover issues relating to humanitarian law and the refugee law. Now, before I go into the course content of this paper, let me in fact again highlight the importance of this paper by pointing out the 2-3 cases which are being covered by the print and the electronic media. The first case is that of Captain Saurabh Kalia. All of you must have heard about the case of Captain Saurabh Kalia. So what was that case, and why the father is still fighting for justice, and which in fact has not been done in the case of Captain Saurabh Kalia. So therefore, which particular law in fact covers the case of Captain Saurabh Kalia? It is in fact this humanitarian law, where in fact you in fact would be going into as to why the family is still fighting for justice for Captain Saurabh Kalia, and why the justice has not been done, has not been delivered till date. Then the second case is of Commander Abhinandan, which this case is of a recent times, where in fact our pilot was being caught by the Pakistani government, and ultimately he was being released. So which particular law in fact was being taken into consideration while releasing Commander Abhinandan? So here lies the importance of this paper. And further, you must have heard about the case of Rohingyas, as to why the Rohingyas in fact were not being provided shelter in India and in some other countries also. So what in fact are the considerations which were being taken into consideration by India while not permitting the Rohingyas shelter in India? So therefore, this is the relevance of this paper, and the paper in fact is very interesting one, and we have the case material which consists of many readings, including the judgments also. Now, going into the course content, because I have a major internet problem today, so I'll be hurriedly going into the various topics chapters which are being covered as far as this paper is concerned. The first part of this paper focuses on as to what is this humanitarian law. Now, so therefore, what is this humanitarian law? What all is been covered in the humanitarian law? In what situation this humanitarian law is to be applied, and what in fact, where in fact the humanitarian law is to be found. Fine. So therefore, humanitarian law means law of war. So it is law of war means that it is covering the situations of armed conflict. So what is an armed conflict? Whether the conflict within the country is also being governed by humanitarian law, or whether the humanitarian law is confined to conflict between the state. Conflict in the sense that armed conflict when there is a declaration of war, or in case of undeclared war. So therefore, this type of conflict in fact is the subject matter, or is being regulated by this humanitarian law. So humanitarian law, in other words, is a law of war. But then the as far as this humanitarian law, which has been covered by 4 Geneva Conventions, these 4 Geneva Conventions, which if you make an analysis of these 4 Geneva Conventions, it in fact is not regulating the warfare. It is only protecting the rights of the persons who are being caught in the conflict. Fine. So therefore, the first point as far as this humanitarian law is concerned, that it is giving protection. It is this humanitarian law is not regulating warfare. This law of war is not regulating warfare. This humanitarian law or law of war, in fact, is protecting the rights of all those persons who are involved in conflict, or in fact who were part of the conflict but are no longer a part of the conflict. Fine. So that is why Captain Abhinandan, the moment he was being caught, so he was not in a position to give a fight to the Pakistani forces. So that is why the case of Captain Abhinandan is being decided by taking into consideration the second Geneva Convention, that is the Geneva Convention relating to protection of prisoners of war. Fine. So therefore, my point is that this first part, which is first part of the paper, which deals with humanitarian law, it is in fact is not regulating warfare. It is protecting the rights of the persons who are party to the conflict. It is protecting the rights of those persons who were party to the conflict but are no longer a party to the conflict. Fine. So therefore it is covering armed conflict, not only international armed conflict but also the non-international armed conflict. Fine. So that is being covered, that is to be taught in the first part of the chapter, which in fact is an introductory one as to what all is being covered into the into this humanitarian law. So therefore, the war between the state and the war within the state. So very unique subject in the sense that this now the international law is to be applied to the internal situations in the state. For example, what is happening in the northeast, what happened in Punjab, and what is happening in Kashmir. So that in fact is the internal problem of India. So how the Indian government is dealing with the internal problem, dealing with the non-state actors. So how in fact the government of India should deal with the non-state actors who are in fact challenging the sovereignty of the state. The international law, humanitarian law, is also in fact covering that situation. So not only in international armed conflict, but non-international armed conflict is also been covered into the international humanitarian law. Fine. Now, another part of this international humanitarian law is that we'll be telling you as to, is there any connection between international humanitarian law and human rights law? So in what situation the human rights law is to be applied, and when is the significance of this international humanitarian law? So therefore, the relationship between international humanitarian law and human rights law is also to be taught in the first part of in the first chapter of this part 1. Fine. Now then, in fact, the second chapter of this first part deals with the 4 international conventions, which in fact are the humanitarian law, which is the basis of the humanitarian law. That's the 4 Geneva Conventions. So naturally, this is to be dealt in detail in the class. But the focus of the second part of the second chapter of the part 1 is the 4 Geneva Convention, which which is giving protection to the persons who are being involved in the conflict. Fine. Now, but then the problem arises that, as we all know, that as far as international law is concerned, international law primarily deals with the state. But now there is an expansion in the subject of international law, and individuals are also the subject of international law. So the question arises that if any state violates any one of the Geneva Convention, then who all is to be held responsible? So who all are to be punished in case of violation of this humanitarian law? So here lies the importance of chapter 3rd and the 4th of the part 1, whereby in fact there is a setting up of international ad hoc tribunal whereby the individuals are being punished for violating the international humanitarian law. Fine. So therefore, since it is no doubt that under the international law, the states are primarily the subject of international law. But then if any state in fact has resorted to war crime, then who is to be punished? So how can we punish the state in case the war crime has been committed by the state? So therefore, here in fact we'll be discussing the relevance of the decision given in Nuremberg Tribunal that in case as far as the international law is concerned, it is only by punishing the individuals that international law can be enforced. So therefore, the focus of the 3rd and the 4th chapter is on to the individual responsibility for violation of international humanitarian law. Then the last part of the chapter of the first part deals with setting up of international criminal court. So why the ICC were being set up? The reason being is that that as far as the ad hoc tribunals are concerned, they were temporary in nature. So therefore the debate started that there has to be a permanent institution which in fact would be punishing the individual for violating the international humanitarian law. So therefore this international criminal court was being set up, but then the major criticism of this ICC is that the ICC in fact was being brought into an existence by the European states. So therefore some critics they point out that it's a European court for Africans. Why do they say so? Because till date as far as the people who are being punished by this ICC, they are in fact the Africans. So therefore that's the criticism of this ICC. But my point is that these are the various chapters which are to be covered into the part 1 dealing with the international humanitarian law. So apart from responsibility of the state, there is also the responsibility of the individuals. Fine. So that's the focus of the first part of this paper. Now the second part of the paper, it deals with the international refugee law. Now the major focus of the second part is on to as to what is the international law relating to the refugees and for giving protection to the vulnerable people who were compelled by the circumstances to leave their own country. So therefore the international community, they realize that there must in fact be some law which in fact should provide protection to these vulnerable section of the people who by circumstances were compelled to leave their own country. So therefore here lies the importance of International Convention relating to refugees 1951. Fine. But then so that's the major international convention which is protecting the rights of the refugee. Now but the major criticism of this convention is relating to the definition of the refugee. Now we all know it very well as that as far as who's to be considered as a refugee, the state, while conferring the status of refugee upon a person, is always being driven by the national interest. So there is a interest of the state. In a way, the approach of the state sometimes is discriminatory in the sense that the state confers a refugee status upon one group of the people, and the refugee status is being denied to the other group of the people. We have seen in the case of the Rohingyas. So therefore, international convention relating to refugee, that would be the focus of the second part of this course content. Then apart from the international perspective, we will also be dealing with as to what is the approach of India as far as this international convention relating to refugee is concerned. So as far as Indian perspective perspective is concerned, that we don't have any specific legislation relating to refugee. Neither we are signatory to this international convention relating to refugee of 1951. So the question is that in the absence of specific legislation, how the Indian government is protecting the rights of the refugees, how the Indian government in fact gave the refugee status to the people who migrated to India in 1971. The major influx of the refugees in India was being witnessed in 1971. So therefore, and how the Chakmas ultimately were been given citizenship by the decision of the Court of India, Supreme Court of India. And what is the response of the state government when the Supreme Court of India is telling the state government that you must in fact give Chakmas the citizenship. So therefore, as far as approach of India towards refugees is concerned, in the absence of specific legislation, the refugees in fact are being given protection by the decision of the Supreme Court. In fact, if you may ask me what is the role of the Supreme Court in protecting the rights of the refugee, it is in fact phenomenal. So it is the Supreme Court of India who, in the absence of specific legislation, is protecting the rights of the refugees. So therefore, the second part mainly is bifurcated into two parts: the international perspective as well as the national perspective. So this is all is to be covered into this paper. So my suggestion to all my students would be that all those students who are interested in the issues of human rights, they must opt for this paper. Reason being is that this will not only help you in understanding as to what are the problems which are being faced by the people who in fact are party to the armed conflict, but also who by circumstances are being compelled to leave their own country. So this is all what I wanted to say as far as this paper is concerned. And I welcome, in fact, all my students to be a part of this course content, to be a part of this paper. Okay, then.
Thank you so much, ma'am, for explaining so well about the importance of this subject. It was really very important information shared by you regarding the subject. Thank you so much, ma'am.
Okay. Thank you, Anju. Thank you.
So with this, we have completed orientation overview or regarding all the fourth semester subject. And as informed you earlier that this program, the recording will be uploaded to the LC1 website and also to the YouTube. So if any of your friend has missed this, they can they can just again watch this program at the YouTube or at the LC1 website. And before concluding this program for fourth semester, because then we'll take a 2-3 minutes break for facilitating the students to join from the sixth semester. Before doing that, I would like to thank again all the resource persons who take out time from their busy schedule and they shared very relevant information regarding the subject here, which is really going to help the students to choose their optional subject. And if even after this, if any one of you is having any problem or any confusion regarding the subject which you want to choose, you can contact any of the subject expert after this program also. Thank you so very much.
Thank you very much, ma'am, for your time, and to all the teachers for giving us insights. And is it possible, ma'am, that we come to know that how do we change the subject which we have already selected?
If you can change the deadline before 17 December, you can change. So that option form, you can change. Again, you can fill your option form because that option form will remain open and the information you will get on the website itself. Okay.
Right. Thank you so much. Ma'am, will we be getting any confirmation like we are getting receipts of all the other forms? As far as admission form is concerned, can we get any confirmation in the form of, say, just a printout maybe that, okay, this is the details which we have filled or selected?
Actually, that I'm not aware right now, but that will inform you. You just check it on the website. If it is possible, we'll inform you there.
Because we have submitted the form and it is only shown on the website that, okay, submitted, but we don't have any confirmation. Like in the future, if we want to confirm or if we want to put into as a perspective, as evidence that yes, we have done that. So we don't have any received any confirmation of any sort, ma'am.
I think later
most of the Google forms have a tick option at the bottom. If you want to receive a copy of the form you've submitted in your email, you can click that and you will get a copy of the form you submit.
Right, ma'am. I will surely check that, ma'am.
Yes, yes.
Thank you so much.
Most of the time, we are able to get the copy. If you there's a tick mark option at the bottom. That before you submit, if it says you get a copy on your email, you will get that.
Fine, ma'am. Thank you so much.
Okay, thank you so much, all of you. Now, fourth year students may leave, and we'll take a break of 2-3 minutes to facilitate sixth semester students. Thank you so much.
Okay, so we are free to leave now.
Yes, ma'am. Thank you so much for your valuable time.